Welcome back to The Agent of Wealth. This is your host, Marc Bautis. Today we're diving into the world of trusts, specifically perpetual trusts, and how they can be a powerful tool for preserving wealth across generations. Joining me is Antony Joffe, an expert in trust administration and the chairman of Sterling Trustees, LLC. Under his leadership, Sterling Trustees has grown to manage over $10 billion in assets, providing independent, conflict-free trust administration services. Antony is also the co-founder of WealthHub, a software platform that streamlines trust administration and played a key role in establishing the South Dakota Trust Association. With over 15 years of experience, a background in investment banking and auditing, and an MBA in finance, Antony brings a wealth of knowledge to today's discussion. Antony, welcome to the show.
Thanks for having me.
All right, so let's start off with the basics. What exactly is a perpetual trust, and how does it differ from some of those traditional trusts that may be more well-known?
Yeah. So perpetual trust, as the name sounds, I guess implies, is a trust that goes on forever. So for wealthier families that have accumulated massive amount of wealth, it's a great way to continue that legacy for multiple generations. And there's also potential tax savings in that, since the capital never really comes out. You potentially could save GST tax as well. So huge potential tax savings for ultra high net worth families.
And so what is it? The beneficiaries are changing over time as the generations change? Is that how it works?
That's
But the
correct.
trust kind of stays intact?
Yep. So most families, set up what's called a bloodline trust, which is a trust that just passes down the bloodline. So, any direct descendants of, the grantor or the, person putting the money into trust would then be beneficiaries going down the line. So kids and their kids, and, way on down the line until, looks like a big tree.
So you mentioned potential tax savings. What are some
Yep.
of the other reasons, or what are even some of the ways that people can save tax by utilizing this?
Yeah. So we're chartered out of South Dakota, so there's multiple sort of potential tax savings. So trusts in South Dakota aren't subject to any state income tax or state capital gains tax. And then potentially with a perpetual trust, you potentially can eliminate generation skipping tax. So pretty huge tax savings there, particularly on the GST side. Where the GST tax is upwards of 40%. So it takes a huge bite when you skip a generation and don't have to pay 40%. So
And
so
so,
those are the big ones are really state income tax, state capital gains tax, potential GST tax, and then obviously trusts are exempt from estate tax as well. So they can serve lots of roles here.
and just to give a definition to our listeners of generation skipping tax and kind of how that operates and how I can get assets to multiple generations down.
Yeah, so typically generation skipping tax, what it means is you pay a tax after you skip one generation. So if a grantor puts money in a trust today for the benefit of, say, his kids, and then his kids' would be the next beneficiaries, the trust would pay a generation skipping tax of 40% when it passes down to that next generation. So, it's a huge potential, bite at the principal of the trust over time.
Maybe you can walk us through the mechanics of how this would work. So let's say I'm someone and I have accumulated a lot of assets. How is the trust structured? Am I just retitling everything into the name of this trust? Do I still have access? Do I still have any control over these assets? Because I think these are things that people would be interested in,
Yep.
in knowing how it's structured, how does it work?
Yeah. So, one thing to keep in mind, listen, a perpetual trust is just a feature of the trust. The first step, obviously, in creating this is, you need to go to, a trust and estate attorney and have them, draft a trust document with, obviously the names of the beneficiaries, how you want that money to be distributed, over their lifetimes and whatnot. And so that's sort of the key, the key first step is obviously having a trust and estate attorney involved. In terms of how you get the money into the trust, everybody during their lifetimes has a lifetime gift exemption of $13 million and change. So between a husband and wife, potentially you could put up to $26 million of assets into a trust, gift tax free. And and then it can obviously grow from there. And then once you eliminate the state income tax and capital gains tax and potentially, the GST tax, you can see sort of the benefits of having a trust, to perpetuate your, I guess your, I might want to stop there for a second, really to perpetuate your, what you've created during your lifetime for multiple generations.
Would I still have access to any of the assets or income as the grantor, even after putting them into the trust?
Yeah, no, that's a good question. So South Dakota has a unique feature. It's a trust called a self-settled trust, and in a self-settled trust, the grantor putting the money in can also be a beneficiary. So in order to make it work, though, you have to have a third-party independent trustee making all the distribution decisions, so that theoretically the grantor who's putting the money in is giving up control of those assets and having a third party make the distribution decisions, so that he's not in control of those assets and therefore potentially put yourself in an estate tax situation.
But as the grantor, I can say, okay, I need $100,000 a year, and I can
Yep.
specify that. And as the trust is created, that the trust is going to pay me out $100,000 a year.
Yeah, you
And
typically don't want to say you want to take out $100,000 a year, because a lot of people set up self-settled trusts really for asset protection purposes. So if you say, listen, I'm going to take $100,000 out a year, and let's just say you get into a situation where you owe creditors money, now all of a sudden you get $100,000 into your name, the creditors can obviously swoop in and take that money. You really want to make that the distribution discretionary at the trustees. Let the trustees make that decision. So you only take out the money when you need it, so that you don't potentially put yourself in a situation where creditors could grab that money.
so, your company is a trust administration
Correct.
company, so
Yep.
how would that work with the grantor, who in this case is also the beneficiary? Does he basically make a request that says, 1 year it might say, okay, I need nothing, and the next year he might say, okay, I need $100,000,
Yep.
and you as the administration company would actually administer that distribution?
That's correct. Yep. So we don't manage any assets ourselves. We purely act as the trustee. We will work with, best of breed financial advisors to manage the underlying assets. We'll look over their shoulders, make sure they're doing what they're supposed to be doing. And then, yeah, no, when the grantor potentially has a need for, I need $10,000 for little Chani for private school costs, he would call us, and, we would make that distribution, uh, you know, based on wire instructions that they would send to us, and, take care of the distribution.
You mentioned protection from creditors. How does the trust do that from creditors or things like divorce or different protection strategies?
Yeah. So South Dakota's got great asset protection laws. They probably have the best asset protection laws in the country today. So once assets are in trust for 2 years in South Dakota, they really become bulletproof creditors. And so they've got sort of the shortest, what we call curing period, in terms of how long it takes to actually cure to become, bulletproof. States like Delaware, for example, have a 4-year look back, and other states are, very similar. So South Dakota's got sort of the shortest period to cure. And really, if a creditor wants to get money out of the trust, I mean, they would have to come to South Dakota, get in front of a South Dakota judge, and they would have to force us to make that distribution. But if the distributions are discretionary and at our only we can make that decision, a creditor can't force us to distribute those assets out to the beneficiary.
Is there a certain asset size that these types of trusts make sense for?
Yeah, well, for us, typically we won't take anything less than $2 million, but there are trust companies that will do smaller amounts. It really just depends how for us, it's just not efficient for us to hold handle a thing less than 2 million based on the fees that we charge. But there are trust companies that will do smaller amounts. When you're getting into sort of the dynasty trusts where this is going to go on for multiple generations, you probably need 30, 40, $50 million initially in trust to be able to have it filtered down to multiple generations. Because once you get down to generation two, well, maybe probably three, four, and five, the amounts that may be left in trust are de minimis, and it probably doesn't make sense to keep them going. So so the perpetual trust really sort of work well with obviously larger amounts of money.
How is the grantor able to change any of the rules of the trust over time? So, say for example, they say, okay, this is how the assets should be distributed, but something happens and they want to change the rules of distribution. Are they, or once it's in there, is it irrevocable and they can't change any of the rules that were initially established?
Yeah. Well, typically you have two types of trust. You have a revocable trust where is basically you lay out the terms of the trust document, but at any period of time, the grantor, if he's still alive, can revoke the trust and take that money back into his own pockets. And so, during that time, you can obviously make changes to the trust document and whatnot. For an irrevocable trust, it's hard to change the dispositive provisions of the trust once it's created and whatnot. I mean, South Dakota does have great decanting statutes, meaning you can change and reform parts of the trust document, mainly around sort of the administrative provisions of the trust. But it's very difficult to change sort of the dispositive provisions of the trust on a going forward basis.
As a trust administration company, we talked a little bit about distributions, but what else in terms of what else goes into administering a trust over time?
Yeah, no, it's there's lots of sort of skills that you have to bring to bear. Obviously, you got to manage the investment side of the trust, making sure that the assets are invested correctly, or generating enough income and whatnot to service the beneficiaries. Obviously you've got the tax side. On an annual basis, you need to file the trust tax returns, and so obviously putting income statement balance sheets together for the trust so that you can actually prepare the returns and whatnot is another role that we play. And then you've got the legal side of it as well, making sure that there's no legal issues as it relates to the trust. I mean, sometimes you may have a beneficiary going through a divorce, and you need to sort of protect them and whatnot. So there's lots of skills that are brought to bear as a trustee that using a corporate trustee really helps families in terms of obviously bringing those skills, but also eliminating a lot of conflicts of interest that happen with family trust. Because typically, what tends to happen is the grantor maybe names oldest son as the trustee, and now younger brother, younger sister have to go to him to get a distribution. And you can imagine that leads to a lot of internal conflict and strife and issues within the family. And so by having an independent trustee like ourselves making those decisions, you sort of eliminate that conflict.
You mentioned initially about like potential tax savings, but how are the assets in the trust taxed year to year? And is it any different if they were out, let's say, held outside the trust?
Yeah. So think of a trust as an individual. So a trust gets taxed very similar to the way an individual gets taxed. Obviously capital gains are taxed at 20%, similar to an individual, and then income gets taxed the same way. So on bond income, for example, or municipal bond income, the only difference between a trust and an individual is on the income side, you reach sort of the max tax bracket at about $14,000 of income, whereas an individual or a couple married or filing jointly, you're going to reach max tax at about $400,000 or $500,000 of income. So sometimes it's more efficient to pass out the income to the beneficiary and have it taxed in their hands versus the trust hands, if you've got a need for that income.
Maybe you can also explain how the trust works with multiple generations. So, as an example, I'm the grantor. I create this trust. I put money into the trust. At some point, and I lay out the rules of the trust. At some point, I die, and now there's another generation that comes up. How do they get included in this trust?
Yeah. So typically, what will happen is the grantor, once they feel the kids are sort of mature enough to know about sort of the details of the trust, will start to bring them into the fold. We'll start to bring them into quarterly calls that we do with the grantor and say the investment advisor, for example. So they start to understand how the trust is invested, what type of income it's generating, and how this income is supposed to be used. And so over time, they start to learn and get involved in it, so that they can then pass this down to their kids and start to talk about it with their kids, so that this sort of uh, rotation just continues to happen, down the family tree.
And how is technology kind of shaped itself in the trust space? Has there been advances in technology in terms of how trusts are administered or even created?
Yep. Yeah. So one of the things that we did was when we started the trust company, really started developing early on Salesforce, just because of the flexibility that it provides in terms of creating workflows and whatnot. And so we developed an app on there that sits on all of our trust officers' desktops. It really automates all of their day-to-day activities. So whether it's onboarding a trust, doing a distribution, administrative reviews, investment reviews, all of that's in the cloud, and time stamped, and approval processes are done that way. So it allows us to be, as efficient as we can, because, obviously as a trustee, you've got regulatory risk that you've got to worry about, and then you've also got the fiduciary risk, and you really have to bring sort of technology to bear to be able to make yourselves efficient and, manage all of that risk. It's hard to do with, pen and paper, which unfortunately a lot of trust companies still do today. I think the trust industry, unfortunately, is sort of probably 10 to 15 years behind where sort of the RIA industry is in terms of technology, but it's starting to get better, and enabling trust companies to be, more efficient going forward.
Do you see any regulatory changes, or even just with political things going on, any changes to trusts?
I don't see anything in the near term. I mean, I think there was talk, if Biden was reelected, that potentially the lifetime gift exemption would get lowered from 13 million down to 3.5 million, which potentially could have led to, a flood of new trusts. People wanted to get assets out of their own name before that happened, and I think with Trump in office, I just don't think they're going to lower that exemption. So um, I don't see really anything over the next 4 to 5 years that are really going to trust or going to change from a regulatory or tax standpoint.
Are there other types of trusts that someone with a large amount of assets should consider?
Yeah, no, listen, there's lots of different trusts. I mean, there's GRATs, there's CRUTs, there's all sorts of techniques to get assets into trust and out of your name to sort of save from estate tax. Because obviously, your lifetime gifts exemption is only $13 million, and you have people that earn billions over their lifetime. And how do you potentially shelter some of that income from estate tax in the future? So there's lots of techniques and whatnot, but that's really where a good trust and estate attorney can help the client in terms of mapping that out, and making sure you've got a good plan in place in order to sort of minimize estate tax on a going forward basis.
All right, Anthony, that's all the questions I have for you today. I want to thank you for joining me on today's episode of The Agent of Wealth. Before you go, how best can people get in touch with you and learn more about what you do?
Sure. Well, they can find out more about Sterling Trustees just going to our website, which is www.sterlingtrustees.com, or people can just reach out to me directly. Again, my name is Antony Joffe, and you can get me on my phone number, which is 610-234-0626, or via email at ajoffe, AJOFFE, at sterlingtrustees.com.
Great. We'll include all that in the resources section of the show notes. Thanks again, Anthony, and thank you to everyone who tuned in today.
Thank you.